May
Item number 59 and 63 of the monthly list. The two section 9 applications, the urgency is what is due is about 5 crores. We check the records, they have absolutely nothing. But we're in some requirement of urgent protection as so far as security is concerned. I will, in one matter, I will.
award, post award, what is it?
No, section 9 free award. Free award. That could be just taken up on anything. Okay? In one matter, I will not take more than 5 minutes. The other one might be a little complicated, item number 63, but 59, I'll actually take 5 minutes.
So we'll only have 59.
Very well. Very well. I'll try my luck with one.
Lordship, may
I be permitted to mention a matter? It's an application. It's an application under section, two applications under section 11. The returnable date was 23rd, Your Lordship. Kindly, I'm praying for inclusion in the list.
Lordship, may I correction, my lord. For correction. Lordship, may I
Mention unless correction to be mentioned. What is the correction you have made it?
only thought instead of 2, it will be 1B. Others.
You have made it in the order.
Yes, yes.
Your Lordship may be permitted to mention a section 11 non-commercial site matter for inclusion in the list.
Lordship, may I to permit to mention for inclusion.
May I be permitted to mention one matter, my lord, for inclusion?
What is section 11?
Section 9.
Section 9. Section 9 you filed it what? When did you file it?
I am the respondent, my lord.
Respondent.
My lord,
Wait.
2021 matter, my lord.
Petitioner is not interested. Why are you interested?
My lord, my vehicle is stuck. My lord, the vehicle which is the subject matter.
No,
of the-
nothing doing. Yes.
May I mention item number 620 and 621 of the combined monthly list. These two are execution applications where more than 84 crore is lying due. Firstly, secondly, there is an award for eviction. Now, from that eviction award, there is a separate execution application pending. They are still occupying, not paying us a single penny. The tenure of my lease, she was a sub-lessee. Tenure of my lease is going to expire very soon. So unless these execution applications are taken up and they are put under some kind of pressure, the tenure will also lapse and I will get nothing. 84 crore is lying payable and they are still enjoying the property, not paying us anything.
Mr. Banerjee is not right. We will have execution mentioned in next week.
Lordship, mentioning upon notice, Lordship, on 15 July, Lordship has passed an order by appointing a sole arbitrator. Lordship, the sole arbitrator restrictions on personal.
You have to move an application.
Lordship, mention kindly include.
Mentioning. Have you moved an application under 14?
Lordship.
You have to move an application. I can't just change it like this.
Okay.
Move an application will.
Okay.
We may be permitted to mention a restoration application of section 11 application that we listed. This is all.
Restoration of 11.
Lordship, may I be permitted to mention?
How did your application got dismissed? When?
It was dismissed on 8th of May.
8th of?
May.
By me.
Lordship, may I be permitted to mention one execution application and 329A application, Your Lordship.
Lordship,
29A you give it, execution later.
Lordship, may I be permitted to mention one application? This is a contempt application. I'm praying for inclusion. Lordship, this is a matter pertaining to Jalpaiguri Circuit Bench. Lordship, the urgency is that I have made an application under Section 5 of the Citizenship Act and also an application for extension of visa. I am a Bangladeshi citizen married to an Indian. Lordship
Why
had
are you
direct.
mentioning my court?
Lordship's order. This is a contempt application, Lordship. This is a contempt application arising out of your Lordship's order dated 26/2026. Lordship, grateful Lordship.
Your Lordship, mentioning upon notice, there is a slight correction in the order.
You made the correction. What is the correction?
In the operative part, the liberty has not been mentioned.
Lordship, may I be permitted to mention a section 9 matter which is appearing as in the your Lordship's monthly list as item 52. Lordship will recall your Lordship has partly heard it, partly heard in fact heard the petitioner. The respondent was
Show me the order. Show me the order.
May be permitted to mention section 9 matter appearing as monthly list item number 52 of your Lordship's list. Lordship, this pertains to cancellation of a development agreement. Lordship has heard the petitioner. I was being led by Mr. Sarvapriya Mukherjee. Mr. Sumandat was replying. Your Lordship had heard the matter in part. Section 9, Your Lordship, some urgency. If Your Lordship can kindly gives it precedence any day convenient to Your Lordship, because Your Lordship has also partly heard it. The development agreement was cancelled, against which I've come up in Section 9. In the meantime,
They have already entered into another agreement.
yes, Your Lordship has recalled. Your Lordship had heard it in part. All I'm seeking any day convenient to Your Lordship, so that Your Lordship can dispose it of whenever convenient to Your Lordship. It's running in the monthly list. Great for Your Lordship.
Your Lordship, I'm mentioning upon notice, Your Lordship, this is a Section 34 application. I'm appearing for the respondent. The petitioner has deposited the money in the court, praying that the matter be included in the list so that it can be heard of. Grateful.
New motion, section 29A, item number 1.
My lord, this is my section 29 application, my lord. We have served twice, my lord. That has returned, my lord. So our direction may be given for alternative service, my lord.
Learned counsel for the petitioner. State that. Where's the affidavit service? How many affidavit of service?
Well,
you have?
2 services there present, and there was another direction, my lord. We have served. That is not complete yet, my lord.
That be completed.
My lord,
That be completed. When will you? We'll keep
my
it
lord,
next,
then keeps it in Friday, my lord.
next week. Let that be completed, then I'll report it in the order.
We'll do that.
Let's keep
I'll
it next.
grateful, my lord.
One, two.
May I please you? Yes. Like Mr. Kar is going to take time, huh? We have.
It may not.
That legal issue, my lord, really, my lord, with regard to my lord, that.
Signing of the award.
Yes.
What are you doing here, Mr. Sharma?
I thought I should come and appear in this court. That is the reason. But I want to withdraw the affidavit that we have filed on behalf of the spot number 3. I
want
will
to
rely
withdraw.
on the affidavit filed by the spot number 1.
I'm going to reply
To
with the
withdraw.
Yes.
Why? What have you stated in the affidavit?
judge against allegation দিয়ে আছে judge against খুব বাজে বাজে allegations দিয়েছে
There's a lot of
Yes,
allegations
in
there.
the judge.
Naturally,
That's why
they become wiser.
No, not wiser.
That if I'm coming, I'll withdraw. I wanted
There are
to
a lot of allegations, Lord, which is,
Shall we allow that, or you want to respond to the
but
allegation?
kindly
Yeah,
hear
what
the
if-
application and then ultimately, if your lordship feels. Lord, there was a tribunal consisted of, Lord, 3 learned judges. Now, Lord, the majority award that has been pronounced, Lord, on that was pronounced, Lord, on 9th
9th of
May, 9th of May. 9th of May. Now, my lord, before the pronouncement, Lord, there were exchange of letters, Lord, between the learned arbitral tribunal. Lord, if your lordships, Lord, kindly come to page 157,
Yeah, na, दूसरा volume.
volume 2.
Volume 2.
here bar করো 2024 to SCC 6
157, if your lordships,
Yes.
Lord, kindly see. The majority arbitrator, Lord, they are forwarding the proposed award. The lordships kindly permits me to place this letter. Dear so and so, you are aware that the Honorable High Court at Calcutta was pleased to pass the following order on 11th November 2025 by extending the mandate of the arbitral tribunal. In view of the submissions of the learned counsel for the petitioner, this court is inclined to extend the time period of the learned arbitral tribunal by a further period of 6 months from today for publication of the award. The learned arbitral tribunal is requested to publish the award within the extended time period. Co-arbitrators have already prepared the draft award and forwarded the same to you by email in the last week of September 2025. And hard copy of the same was also handed over to you soon thereafter.
However, the co-arbitrators were not communicated anything about the acceptance and rejection of any modification of the said award or even drafting of any new award by you, in spite of the fact that co-arbitrators requested you repeatedly to finalize the award. Then it may not be out of place to mention that the previously on different occasion you assured the co-arbitrators to finalize the draft award, but on health ground you could not do so. However, afterwards, we are happy to learn that you have recovered from your ailments and again started your normal activities, including discharging the function of arbitrator in respect of different arbitration proceedings. One of the co-arbitrators, so and so, while tried to contact you on the mobile phone, and then this says that there were attempts made to contact the presiding arbitrator, but she could not be contacted. And then it says that we are unable to wait any longer. Now, Lord, as a matter of fact, yes. As a matter of fact, Lord, the oral hearing of the parties was concluded on 11th of August 2025. And then, Lord, came the order under section 29A. That was on 11th of November 2025. That is at page 155. Your Lordship will find the order. This order, Lord, records that the final arguments have been concluded on 11th of August 2025. And Lord, page 156 is the order that your Lordship had passed. Now, Lord, what happened is that there was a reply to this letter by the presiding arbitrator, which is at page 159. But actually, it seems that the learned presiding arbitrator said that on health ground, she was unable to complete the process. Yes. Now, Lord, with this, there is a notice which was served by the majority arbitrator, which is at page 160. Where they published the award. Now, Lord, at page 161, our advocate on record, Lord, sent a notice on 8th of May saying that we are taking out an application under 29A in view of the request contained in the letter of the learned presiding arbitrator. But despite receipt of this letter, the award was published, Lord, on 11th of May. That is at page 165. Now, Lord, there are two aspects of the matter. One is that, Lord, now, even if, Lord, this award comes, dissenting award, which she had expressed, Lord, it will be taken as an opinion. Now, Lord, the effect of the opinion is what is discussed by the Supreme Court. If I may just point out that, because, Lord, it is not going to prejudice the award holder in any manner whatsoever. Your Lordships kindly, Lord, looks at this judgment. This is reported in 2024, volume 2 SCC, page 613. Volume 2, 613. Sorry.
You're saying that it will be an opinion, then in that case, your application under 29A itself is.
Lord, I just want to, Lord, add something. I just, Lord, want to show
Just to clarify that if you yourself are saying that
no, it's an award. It is an award, but Lord, it will have the effect of an opinion. I tell your Lordship why. Please come to paragraph 29.
Yes.
That paragraph 29, before ending the discussion, it would be also necessary to highlight one aspect which is likely to arise in some arbitration proceedings, especially when it involves adjudication by multi-member tribunals. This aspect was highlighted in Russell on arbitration, where the relevance of a dissenting opinion was explained as follows, as quoted by Dakshin Haryana Bijli Vitaran, so and so. Dissenting opinions. Any member of the tribunal who does not assent to the award need not sign it, but may set out his own views of the case either within the award document or in a separate dissenting opinion. The arbitrator should consider carefully whether there is good reason for expressing his dissent, because a dissenting opinion may encourage a challenge to the award. This is for the parties' information only and does not form a part of the award, but it may be admissible as evidence in relation to procedural matters in the event of a challenge, or may add weight to the arguments of a party wishing to appeal against the award. So, my lord, this is the effect.
So then if this is the effect and if we rely upon this, then you are admitting to the fact that there's an award. And the fact that she has sent a mail whereby she's saying that she is going to dissent is a dissenting award, which you can use at 34. It's an
34,
opinion.
34 is,
I'm just saying that. Then 29 goes.
34 is
Today
always,
if you today admit it, that it is a dissenting award and relying on this para 29, then it is just a dissenting award which has come, though there is an award by majority, which is the final award. Then 29A is not required.
the only thing is that why I filed this application is because, Lord, this dissenting award is the purpose of the dissenting award is to lay down the process. I mean, to prescribe the procedure that was followed, and Lord, this will
No,
give me
dissenting award would not be only to lay down the procedure that has been followed. Dissenting
the
award,
other reasons also. The
Yes.
reasons for
would-
dissent.
Yes, correct.
The reasons for dissent will assist me, Lord, in my application under
Yes, but
section
then
34.
if we take that, then this application is infructuous today, isn't it?
Lord, if your lordships, Lord, kindly sees also paragraph 32 once.
Yes.
But even if the original award is set aside, this can't be taken as an award. That's what paragraph 32 says. It is therefore evident that a dissenting opinion cannot be treated as an award if the majority award is set aside. It might provide useful clues to the case in case where there is a procedural issue which becomes
So then
critical.
why should we do this academic exercise under 29A when there's an understanding as far as you are concerned that it's already an award? Then where's the question of
Lord,
extension of time?
only thing is that under 29A, even after passing of the award, and application lies. The only issue is that insofar as
The passing of award, why will an application lie?
that 29A, if
For
you're
what purpose?
for extension of the time, for extension of the
If we
so
are,
that is, of course, in a case where the award is out of time. I appreciate that. There is no difficulty on that. But not the issue is that insofar as the dissenting award is concerned, Lord, the arbitrator here was not given a fair chance because she wanted an extension of time. Therefore, Lord, it could be, your lordship is right that could be a ground under 34. That's one thing to say. That would be a ground under 34. But Lord, I am saying, Lord, if the time is extended, no prejudice will be served because this will not be read into the award. This will
no,
be
it will, because they are saying, if I understand correctly, is that award has already been, finalized. It's an award. So any extension will be of no relevance, no purpose will serve.
it's
That's what,
it's logical. But Lord, the issue is that today, then Lord,
not only logical, it's legal also.
no, then Lord, the
If we
embarrassing
assume your argument,
then the embarrassing question will come because Lord, we will have to ask for return of the remuneration paid to the arbitrator, which I wanted to avoid. This we are
but,
entitled to.
but for that embarrassment, this
No.
court can't do an academic exercise.
Lord, we under
There are
20
many embarrassments in this case.
I know.
We will not get into.
I know. There's no end of embarrassment, Lord. That we will travel that path, my lord, when we come under section 34.
Correct.
But Lord, as of now, this becomes a unnecessary exercise, Lord. We will have to do that. There is no other way.
This exercise is not relevant.
But relevant because in the context of 29A, because if your lordship finds
in the context of 29A only, I am saying that this exercise is not relevant. Because if the award has already been passed, then where's the question of any extension being granted?
no, the extension is with regard to the dissenting award.
I think she said she'll give a dissenting award. She has not done anything.
For that, Lord, the time needs extended. Otherwise, Lord, she can't because the mandate stands.
If we assume that the dissenting award, well, whether she should have done it in time, but anyway, the award is final. In terms of this judgment also, if we take that, it's an award passed by majority. Now, the question is whether, like earlier on when last time the matter was taken up, the question which arose was whether signature of all the arbitrators are required or not on the award. Right, Mr. Banerjee?
That is section 31. If your lordship kindly sees.
That's exactly what was being argued by Mr. Saturu Banerjee.
Kindly, my lord, have a look at section 31.
That's right. And that's the reason why we wanted to hear it. Because the color arbitration. The 31 says that everyone has to sign.
Everyone has to sign, and if someone doesn't sign, then there has to be a reason for omitted signature. That is 31(2). But your lordship is right that, Lord, this could be a ground taken in section 34.
Yes, for setting aside.
Lordship is right there. I'm not joining issue there. But Lord, I'm saying that if the dissenting award is given today, none of their right is going to be prejudiced. In any event, it will be not read into the award.
Their right would be prejudiced to the extent that for them this is an award.
It will not be treated as an award. That's the law. They say that it will not be treated, even if the award is.
They are arguing contrary to that they are saying that it is an award passed by majority.
This is passed by majority, but if there is a dissent indicated by one of the arbitrators, that dissent the party should have, because I have suffered the award. I must have the benefit of that dissent. We are going to be prejudiced if that dissent doesn't come, because that is going to help us in our argument under 34. The purpose is not very clear that it is not going to be read into the award. It will be a separate document treated as an opinion. The evidentiary value, your lordships will judge in section 34.
So let us read 31(2).
Yes.
It says, for the purposes of subsection 1, in arbitral proceedings with more than one arbitrator, the signatures of the majority, the word is majority of all the members, which would not, it can be read as it's not all the members, majority of all the members.
Majority of all the members.
So here there are 3 arbitrators. The majority of all the members are 2 arbitrators.
Yes, only rider. Your lordship is right. Subsection 2 gives a rider also.
Yes.
It says
all the members of the arbitral tribunal shall be sufficient so long as the reasons for any omitted signature is stated.
That is a test to be gone into in 34, because in 29A this is perhaps not relevant.
So reasons can be
this application and
inferred from the proceedings.
Sorry.
Reasons, and it's just allowed thinking. I'm not saying that. I'm saying that reasons can be inferred from the proceedings, whereby from conduct also you can come to a reason that the.
No, that is definitely without an inference, which can be drawn, and that inference will be drawn. Obviously, Lord, that inference is going to be drawn. There's no difficulty with regard to that. But Lord, I'm just saying that it is an opinion of the third arbitrator, which will reflect.
No, I understand your predicament to the extent that the benefit of dissent,
that is
which you can avail, is not available.
Exactly, and that is the only reason I have come to court. I am not, Lord, here questioning, Lord, whatever the way the award has come into existence. That I will do, Lord, when I file a section 34 application.
Now, whether I have a right in 29A4,
Now,
that has
if
to be
your
exa-
lordship
that
kindly
has
looks
to be
at,
examined,
kindly have a look at 29A.
because once an award has been passed, and in terms of 31 also, I will rather interpret it's an award.
Lord, there is no doubt, Lord, that it is an award. There is no doubt.
If it's an award, then the mandate of the tribunal ceases to exist. And any further 29A application cannot be.
But
Because 29, what is the purpose of 29? Let's read.
kindly have a look at 29. Lord, kindly come to straightaway 29A4. If the award is not made within the period specified subsection 1 or extended period, the mandate of the arbitrator shall terminate unless court has either prior to or after expiry of the period so specified extended the period. Prior to or after expiry of the period. So specified extended the period. Provided that while extending the period under subsection, if the court finds that the proceedings have been delayed for the reasons attributable to arbitrator tribunal, then it may order reduction of fees of the arbitrators not exceeding so and so. Then proviso is not important for us. When it says the extension of period preferred to in subsection 4 may be on the application of any party and may be granted only for sufficient cause and on such some terms and conditions as may be imposed by the court. So, my lord, I am relying on 29A4. Either prior to or after expiry of the period so specified, extended.
That is during the continuance of the arbitral proceedings.
Your lordship is right. Lord, there was a case where, Lord, the award was published beyond the period prescribed. Then, Lord,
show me.
There was a judgment of the Supreme Court, that is, Lord, 2026, Volume 5. If your lordship would kindly come to.
But don't you have a better case in 34?
I have. Lord, no doubt I have. I am, Lord, only seeking this direction because, Lord, I want the dissenting award to come. Because that will show how, Lord, the procedure
But
was
don't you think
bypassed.
not? If you don't have a dissenting award, that's more beneficial for you.
Lord, even if I don't have the dissenting award, I can rely on the proceedings. Which
That's
will,
what I'm saying.
which will,
Don't you think that's a better line of argument in 34?
Press code na code.
Lord, I think your lordship is right. But Lord, also kindly think that, Lord, then I lose.
34, no, you don't lose anything. You can actually say that, you know, the award there was a dissenting award which was supposed to be passed. It has not been passed. I mean, there are many
Correct.
facets to the argument.
Correct. But I'm just contemplating this, Lord, because I'll be losing the advantage of the view of this presiding arbitrator.
Rather, you'll be getting advantage of not having the view of the arbitrator.
I don't know, Lord, weighing the two, which is more beneficial. But Lord, paragraph 21, kindly, Lord, have a look. Lord, kindly come to 21.6, the conclusion part. There is no statutory period prescribed time limit for the court to exercise the power under 29A4 for extending the period, except for its own discretion. The court can exercise the power before or after the expiry of the period under sections 29A, 1 or 3. Further, there is no prescription of an outer limit for extending the time for the conclusion of arbitral proceedings. Given this power, the court will exercise it with circumspection, balancing the remedy.
That's where you should stop. Further, there is no prescription of an outer limit for extending the time. Perfectly fine. for the conclusion of the arbitral trial.
Look, the problem is
In concluded.
here in this case, Lord, after conclusion of the arbitral proceedings, Lord, when the award was published, after that this application was filed. Your Lordships will find the discussion, Lord, in paragraph
22 also.
22, 23.
And you discuss the award. Yes. After
Section
expiry.
29A of the Act does not in terms bar an application for
But
extension
why
of the
don't you discuss with your client and see if it is relevant or not, this application? Why don't you examine it one more time and see if it's, you really want to press it so hard to,
So kindly it a discussion with me and Dr. Ki. Dismissal with me and Dr. Ki. Let's come back, Lord,
I think that's better.
whenever it is convenient.
Just examine it, whether it's that beneficial to press this. Third, Learned Senior Counsel, Mr. Joydeep Kar, list for further here. When do you,
Later file, sir, later file.
Copy. When
Reply.
the
Next
reply
Monday.
may be kept on record.
Monday?
Next Monday.
Next Monday.
next Monday, no?
আপনি আছেন তো, sir?
Mr. Banerjee? Yes. You're here? Next Monday? Yes, sir. Well, I'm here.
Maybe the Supreme Court is not functioning fully.
Next Monday. You come back again, Mr. Sharma?
Thirdly, it will be a pleasure to meet you.
He'll have you. Enjoy the food. Which I have been doing.
Lord, I want to.
No, sir.
We'll see that.
Next.
Just
No.
consider
We'll see that.
recording my statement that
We'll
I
see.
made that statement.
We'll see. Who's filing the reply?
Yes, we are filing.
Affidavit solicitor on record. Reply filed by the. You're filing the reply for. Reply filed by the petitioner to the affidavit in opposition of respondent number 2 is taken on record. Reply filed by the petitioner to the affidavit in opposition of respondent number 1.
No, it's fine. Third is.
But my application under section 29A. This was the application where arbitration was under the aegis of the West Bengal Micro Small Medium Enterprises Develop Facility.
He was opposing it.
Yes, that's
My lord, it is opposing on jurisdiction, my lord. Well, at the post award part, my lord, I have already placed. It's permissible. On jurisdiction, my lord, may I file my affidavit in reply? এটা তো? পরিচালন রাষ্ট্র মনে করো। My lord, in their affidavit in opposition, the respondent had relied on a number of judgments of various honorable courts, high courts. পরিচালন রাষ্ট্র judgment-টা দাও। My lord, after all those judgments, there is a judgment of the Honorable Supreme Court of India on this point, my lord. Lord, this is 2025 SCC Online SC 1111. Copy উনাকে দাও। But here the objection raised was there was an agreement between the parties which provided that there was a forum selection clause which provided courts at Delhi will have jurisdiction. Here, my lord, this was an arbitration under the MSMED Act where, my lord, section 18 provides that the jurisdiction will be where the supplier unit is located. Kindly sees the judgment reported in 2025 SCC Online
Application.
29A, my lord.
There's some GA on
The amendment application.
You have filed.
Yes, we had mentioned last time the name is different from what is now on the cost title.
You have made the correction.
No, that order, my lord, will possibly have to make.
That name is reflected
Correct.
even in the arbitral award. The
That has to
network-
be done.
That has to be done first, yes. The application time I don't need. What's the name?
The present application has been filed by the respondent saying for amendment to the cost title by substituting its erstwhile name ATC Telecom Infrastructure Private Limited with its name Elever Digital Infrastructure Private Limited. Consequent upon a change of name of the company. Full stop. It is submitted that the respondent changed its name with effect from 17/10/2024 pursuant to a certificate of incorporation issued by the Ministry of Corporate Affairs. Full stop. Said change has been duly acknowledged by the Department of Telecommunications. Full stop. The document annexed to the application prima facie established that there has been only a change in the name of the company and not its corporate identity. Full stop. In view of thereof, the amendment sought is formal in nature and necessary for proper adjudication of proceedings. Full stop. No prejudice would be caused to the petitioner if the same is allowed. Accordingly, the application is allowed. The petitioner shall carry out the necessary amendment in the cost title and the connected records within a period of
1 week, 1 week,
Period
well,
of
2 weeks,
1
kindly
week.
2 weeks, because
within a period of 2 weeks from date.
Well, subject to what you lordship feels, if this is the only argument that my friend has, this can be sorted in the next 5 minutes.
So let it-
Judgment,
This has to be carried out. Then only
I'll
will
leave it to you, lordship. And I just thought I was trying to save your lordship's judicial time because that this can be.
no. But if you don't have this, the
Right, I'll leave it.
formal
I'll leave it.
amendments will
I'll
have
leave
to
it.
be made.
I
formal
thought
cost title has to be
Very.
within a period of 2 weeks. Just after 2 weeks.
Great.
It is. Yellow. Any replies on the petition? Reply is for the petition, not for the GA. The necessary was submitted. Reply filed by the petitioner to the affidavit of opposition is taken up.
Okay.
Great. My lord is listing after 2 weeks. Well?
You have filed your affidavit of opposition.
We
You
have.
filed a reply for the.
We have filed our
petitioner.
reply.
Yes, yes.
Pleadings are complete.
I'm requesting for 2 weeks. Well, that's the next to next
2 weeks
Monday.
she had asked for the
That will
correction.
be
1
needed in
week.
the department.
You
This
can
time
do
will
it
be
in 1 week.
necessary.
We'll have it after 2
Yes.
weeks.
My lord, we will take immediate steps, my lord, but in the department, my lord, how much time will be needed? Not
weeks
really
later.
on us, my lord. We will be doing it expeditiously, my lord.
1 week, I think.
Two-
should be sufficient. We'll keep it after 2 weeks.
My lord keeps it up to 2 weeks, my lord.
After 2 weeks. Keep it after 2 weeks.
Right.
2 weeks के बाद date bro. 1 week. She'll carry on amendment 1 week.
I think should be
It's after 2 weeks.
great.
Grateful. Great.
My lord, I'm appearing for the petition, my lord. This is section 29 application.
Who's on the other side?
Your lordship, the other side is not appearing, but they have given their consent with regard to the extension, your lordship. Your lordship, we have served upon them. Your lordship, it has been served. They have received it.
Services there, no?
Yes, your lordship. Lordship, this is the second extension. Your lordship will find the first extension extended by this honorable court
Page.
at page 30, your lordship.
Page 30 is sole arbitrator's order, not page 30.
Your lordship, I apologize, your lordship, page 32.
Affidavit of service taken on record, full stop. Although the respondent is not present, comma, an email received from the respondent has been produced before this court, comma, indicating that the respondent does not have any objection to the extension of the mandate of the learned arbitrator. The email is taken on record. Full stop. The affidavit of service also indicates that the respondent has been served. What is the stage?
Your Lordship, it's at the stage of argument. The respondent is about to start their arguments.
Learned counsel for the petitioner submits that the matter is at the stage of final argument.
Final arguments.
This court finds that considerable progress has been made in the proceedings. Full stop. Ends of justice demand that the mandate should be extended, comma, to enable the learned arbitrator to make and publish the award. Full stop. Accordingly, the mandate of the learned arbitrator is extended further for a period of 3
1
months.
year, Your Lordship.
Why 1 year?
Your Lordship,
Final
the respondent has got a medical condition. Specifically, the lawyer also is unable to come because he lives in Guwahati, and right now there is a flood which has struck Guwahati. That's why.
Oh, 1 year. For a period of 8 months from the date of communication of this order to enable the learned arbitrator to make and to conclude the proceedings and publish the award within the extended time period. Accordingly, it is answered.
Deeply pledged.
I am for the one.
Your Lordship, this is my application under Section 29. I'm the claimant in the arbitral proceedings. The arguments have been completed and the matter has been reserved for final order for the award. The mandate expires on 1st August, Your Lordship. I'm praying that
Was it extended earlier?
it was extended earlier. The order, Your Lordship, is at page 29. Lordship, it is extended for a period of 1 year. This is a construction contract and a total of 75 sittings have been held. And 4 witnesses have been examined in total.
You don't have any objection? Take note. This is an application for extension of the mandate of the first paragraph under section 5. So, learned counsel for the petitioner states that this court, by order dated 30th July 2025, had extended the mandate of the arbitral tribunal for a period of 1 year. The same expires on
1st August 2026.
1st August 2026. Learned counsel for the petitioner submits that the matter is reserved for publication of the award.
Publication of award.
First off, learned counsel for the respondent states that he has no objection to the present application. Full stop. To serve the end of justice, considering the advanced stage of the arbitral proceedings, the mandate of the arbitral tribunal is further extended for a period of
6 months, Your Lordship.
Is it a big 6 months? Okay. For a period of 6 months to enable the learned arbitrator to publish the award with the aforesaid arrangements for the application stand.
1st August. Expired. Grateful, Your Lordship.
This is my application, similar application. Arbitrator, appointed by this honorable court, and the
Dated? When was the arbitrator appointed?
arbitrator was appointed. I'll give it also.
Any extension before?
No, this is the first extension. The pleadings have been completed. The evidence has just commenced. In fact, initially it was suggested that the extension can be had before the arbitral tribunal. Accordingly, a request was made where it was recorded that the arbitrator does not have jurisdiction. We should move the honorable court. Hence this application. Yes, first, yes. Yeah, first was before that.
Period was left, naturally the arbitrator didn't extend because the extension should have been in January, December, they applied in April, so he had not. So Lordship extended as
on the petition.
other points to argue.
First paragraph, this court by order dated 11/9/2024 appointed the sole arbitrator to adjudicate the dispute between the parties.
Yeah, what? Agriculture?
The petitioner,
Prayer?
learned counsel for the respondent submits that he has
12
no
months.
objection to the present application to the extension of the mandate of the
And
arbitrator.
you do not regard that passes a fault.
Do you have any objection?
I'm not raising, don't regard, it causes problem.
If you have any objection, you tell me, I'll deal with your objection.
No, I have no.
Then why?
I leave it to you.
Last time also you had
Last time,
made an objection before the learned tribunal.
that was 2 months, they wanted 6 months, he didn't have the time.
So no objection.
Board's power is there, but as well.
I know, but if you have any objection, I'll deal with your objection.
Just said that sometimes it's nice to be careful.
No. This has to be recorded. Why should you have any objection to the
No, not at all. I have gone there.
Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sole arbitrator. Full stop. Having regard to the stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a
12
period
months.
of 1 year
I'm grateful.
from date.
Very grateful.
Your Lordship, this is my application under section 29A, seeking extension of mandate. On the last occasion, Your Lordship, the mandate was extended by an order dated 7 January 2025, which is appearing at page 11. Now, Your Lordship,
The other side.
Your Lordship, the other side has not been appearing. The last time that the other side appeared was on 30th of August 2023 before this High Court during a section 29A application.
Yeah.
Thereafter, they have not been appearing and the arbitral proceedings have been marked ex parte.
Where's the affidavit of service?
Your Lordship.
They have been served?
Yes. Your Lordship, this is for both 7 and 8 if Your Lordship will take. They're connected matters. To 7 and to the
There's the tracking report.
track report. Your Lordship, it is.
Oh. For both the matters.
That is 7, Your Lordship. This is for 8.
No tracking report.
Your Lordship, it's there.
In this one, it's not there. The notice is there. Tracking report. Where's the report that it's been delivered?
Lordship, it is there.
Shows that you have sent it. This only shows you have sent it. Where's the report? Tracking report. Go on the website, get the tracking
Your Lordship,
report.
I will amend the
Right.
affidavit of service.
Not today. Simply not today.
Great.
Come with the report. Will not today.
On 9.
Lord, in 9, my Lord, I am for the respondent number 4 and 5.
My Lord, I'm on behalf of the petitioner.
Date paper virtually. My Lord.
I'm being led by Mr. Rohit Banerjee. My Lord, Mr. Banerjee, due to some personal reasons, could not come to court today.
What do you want?
My Lord, I'm praying for an adjournment for a day.
Why you do it?
My Lord, Mr. Banerjee wants to address certain facts.
You don't want to?
My Lord, there are certain facts that he wants to address to you
Not today.
physically.
These opportunities. You should do it. Not today.
Affirmative application item number 10.
This is I am for the petitioner. This is my amendment application, my lord.
What?
My amendment application, my lord.
What?
My amendment of my lord, there are twofold of amendment we have sought for, my lord. The first amendment is for the implement of the legal heirs. The petitioner has expired sometimes in the May 2026, my lord. 17th May of 2026. And we have to implement the legal to brought the legal on record, my lord. The second fold of amendment is that, my lord, during the pendency of the the instant proceedings, my lord, the respondent number 1 and 4 has merged together, and respondent number 2 and 3 has merged, my lord. My lord, I will show from the record, my lord, the amalgamation order, my lord. So there's a fold of amendment I am prayed for. My lord, kindly come to paragraph 4 of my application, my lord.
You have any objection?
Lordship, I want to file my opposition, my
My
lord.
lord, there is,
There are certain discrepancies which has been recorded by earlier bench.
my lord, on the base.
Just file my opposition, my lord.
My lord, similar matters is pending, my lord. They have preferred implemented legal heirs on the same terms, my lord.
Lordship, I need to file my opposition, please.
Take down. The petitioner.
My lord, kindly record my submission acted on they have already implemented the same set of legal heirs in the other proceedings, my lord, before this court, my lord.
Learned counsel for the petitioner has filed the present application seeking amendment of the cost title to reflect the subsequent corporate restructuring and amalgamation of the respondent companies, full stop. The petitioner seeks substitution of respondent number 1 and 4 with Future Enterprise Limited through its resolution professional, Mr. Avil Menzies, and respondent number 2 and 3 with Future Market Networks Limited. Learned counsel for the petitioner also, the present application also seeks substitution of the petitioner's
My lord, to implement the legal heirs of the petitioner, so this is petitioner, my lord.
the petitioner further seeks implement of the legal heirs. Full stop. Learned counsel for the respondent opposes the present application. She seeks and is granted 2 weeks.
3 weeks, my lord.
My lord,
Time to
my
file.
lord, 3 weeks, my lord, because this is my application, my lord.
Client is
My
based
lord,
out of Bombay, my lord. 3 weeks.
3 weeks time to file her affidavit in opposition. Reply to the same if any within 1 week, list after 4 weeks.
I'm obliged.
Number 11.
This is my application, your lordship. In the last occasion, the respondent has filed an opposition, but I'm a bit out of time to file my reply. But I'm
That is it.
seeking an extension of a week to file the reply, lordship. Several allegations
For
have
the
been made.
petitioner seeks and is granted further time of 2 weeks to file his reply to the affidavit in opposition. List after 4 weeks.
Grateful, your lordship.
my lord, this is my application. I am filing affidavit of service. I have served by hand. Today they have appeared.
Opposition.
I will be required, my lord, to use an opposition. My lord, it's hopelessly barred by limitation. That is what my contention is. There is a notice which has been issued by the petitioner, my lord, as early as on 18th of February, in February, 3rd of February 2018. They have terminated the contract on 10th of March 2018. They have issued the Section 21 notice, my lord, as late as on, my lord, in March 2026, 16th of March 2026.
Issue of limitation can be looked into by the arbiter.
My lord, I understand, but my lord, in the present case, the Section 21 notice having been issued at such a belated stage, my lord, it becomes a dead claim. That is what my contention would be, my lord. And my lord, in that case, my lord, I would be, my lord, required, my lord.
I don't give time for affidavit.
I understand, my lord. My lord, a short affidavit, I'll file it within 3 days' time.
If I see there's a reason, argue.
My lord, first thing is
Only if I see there's a
with
reason
regard
to
to
be-
the limitation.
Yeah.
Limitation is the subject matter of the learned arbitrator. This is a Section 11 court, and my lord, before my lord, I have to prove the validity of an arbitration agreement.
and that I have served notice under section 21. My lord, kindly come to page 20, running page 27 of my petition. This is the arbitration clause, my lord. My lord, they had filed, before coming to the main crux of the matter, they had filed an application under for specific performance. And thereafter, we had filed an application under Section 8 of the Arbitration Conciliation Act, which was finally ordered as per running page 65, which was ordered on 4/1/25. Thereafter, again, dilly-dally tactics done by the respondents in this case. And so, after long terms of negotiation, nothing has come to fruition. As a result, we served our section 21 notice, appointing one advocate Arindam Kundu as the
Who had
arbitrator.
filed this title suit?
They had filed.
So they are delaying it.
Malad, that has Malad. Very well. Let my learned friend come.
My lord, this is arising from a development agreement. They are the developer. Now, they have not made any construction. They have not taken any fruitful steps, and now they are delaying. This is what is the current situation, my lord. If my lord appoints a single arbitrator, which my lord has ample power to, I can refer to a judgment as well. My lord, the matter can be resolved by way of arbitration. And my lord, the title suit was disposed of referring parties to arbitration, wherein in page 65, miscase 125. The operative portion comes in page 69, the ordering portion, where this miscase and the same be allowed on contest, no order as to cause, and title suit 7/2018 hereby referred to arbitration, since the civil court has no jurisdiction over the subject matter. According, my lord, we served section 21 notice, and thereafter they rejected our appointment for arbitrator, our nomination. As a result, we have come before this honorable court. Their reply is in, my lord, Annexure G, page 73.
Your agreement is dated August 5, 2012.
Yes, my lord.
And this is a development agreement.
Yes, my lord. This is a development agreement of my property, which is I am the landowner. And as regards to limitation, my lord, that is the subject matter of the arbitral tribunal. They can raise that issue there as well.
Yes. That's all?
Yes, my lord.
Malad, agreement of 2012. My client goes on to file a suit in the year 2018. Prior to that, Malad, that was subsequent to Malad, the notice of termination having been issued in March 2018. Prior thereto, Malad, in February 2018, there is raised a dispute. In March 2018, they cancelled the development agreement.
Okay.
I file a suit for specific performance of contract, Malad, in the year 2018. Now, Malad, subsequent thereto, my learned friend's client filed an application under Section 8 of the Arbitration and Conciliation Act in that particular suit, seeking to have the matter referred to arbitration. Now, Malad, pausing here for a moment. In terms of Section 55, Malad, of the Limitation Act, Malad, as soon as they have notice that I am not performing in terms of the contract, they could have referred the matter to arbitration. Since 2018, the Section 8 application had been pending.
Very good.
Now, Malad, subsequent thereto, after the Section 8 application was disposed of, then also they go into a deep slumber. Since January 2025 up to Malad, June 2026, they keep on waiting.
Go and argue all this before the arbitration. Nothing.
Malad, in that case, Malad, if your lordship is pleased to allow me one day, if I can permit your...
Forward.
I'll place a few judgments, Malad, because I thought I will be required, Malad, to file an affidavit in such regard, Malad.
Tomorrow. Tomorrow. Day after tomorrow.
Day after tomorrow.
There's no question that I'm going to entertain.
I completely understand what is troubling you.
Have to go before the arbitration.
But Malad,
issue of maintainability, limitation, all that will be decided by the arbitration. Nothing doing.
The only thing, my lord,
Can
which
give me
perhaps I
100
would,
judgments, nothing is going to change.
the only thing, my lord, which perhaps I would like to canvass before your
Sorry,
lordship
that's
is
not a
if it's a
deadwood.
deadwood
It's
claim.
not a deadwood claim. Not at all.
Very. If then of course,
2012 agreement, 2018, you go to the court.
my
Title.
lord, I go to the court.
Yes, so what? That's all right.
But my lord, until unless
Matter.
very well, I'll try and satisfy your lordship.
Not deadwood claim is that nobody has done anything. There's no this side over it. It's not a deadwood claim.
Perhaps I'll try, my lord. Very well.
The affidavit of service. Wednesday. Affidavit of service taken over.
As my lord pleases. We have a judgment to counter their argument regarding limitation. We'll provide that on Wednesday.
Bring Trish, bring all the judgments.
My lord.
We'll keep it affidavit of service. Give it back to him day after tomorrow.
Very well.
Great. Great.
Now 30.
Lordship.
Yes.
I appear for the petitioner, your lordship. It's a section 11 application, your lordship. This is regarding.
We have got the
I have got the your lordship. Can I then place directly the act, your lordship, or should I give a
brief background.
your lordship? There was a contract with the respondent, your lordship, whereby there was an arbitration clause, whereby they were supposed to make a construction of a tower. They made the construction in 2022. They left. At page, your lordship will find the agreement at page 11, deed of lease. At page 21 is the paragraph 6, your lordship, is the specific arbitration clause. Page 21. Your lordship.
Days of arbitration.
Your lordship, the deed of lease was executed in Calcutta. They had kept this blank. This was provided to us when we filed the suit. The suit, the order was at Calcutta, your lordship, and page 11, your lordship, executed at Kolkata.
Page
Page
11.
Page 11, your lordship.
Page 24 provides the governing law.
24 is there, yes. Yes.
Your lordship, at page 34, your lordship.
You're disputing it.
2 points. Legal.
Yes.
One.
Let him finish it if you're disputing.
Yes.
Yes.
Your lordship, at page 34, your lordship, we had filed a suit. They had filed a section 8 application. It's the order starts at 34. The operative part is, your lordship, at 39, where the section 8 application was allowed. Thereafter, your lordship, I had given notices. The notice, your lordship, is at page 81. Your lordship, in the notice at page 82. Lordship has got page 81 on the notice.
Lordship, the Lordship, last occasion, Your Lordship, the point was raised that 37 days. Your Lordship kindly sees section 21 once, Your Lordship. Lordship has got section 21. That may be allowed, Your Lordship, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. There is no specific 30 days prescribed here that it has to be specified. In section 11,
Yes.
Lordship kindly now turns to section 11 once, Your Lordship. Section 11, subsection 4, Your Lordship. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from, Your Lordship has,
Yes.
Lordship, subsection 4, Your Lordship.
Yes.
If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the two appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration or by the High Court in case of arbitrations other than international commercial arbitrations, as the case may be. Subsection 5, failing any agreement referred to in subsection 2 in arbitration with the sole arbitrator. This is with regards to our case, Your Lordship. If the party failed to agree on the arbitrator within 30 days from the receipt of a request by one party from the other to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. So, Your Lordship, this was made, Your Lordship, in 17/7/2025. We have filed in May 2026. There is no prerequisite in 21 that 30 days have to be mentioned. Even if we had mentioned 7 days, that period of 30 days has lapsed. Lordship, I have some judgments also. Delhi High Court, it's unreported. Lordship, kindly, these two judgments. I'm giving a copy. Lordship, firstly takes ARBP 558 of 2023, paragraph 9, Your Lordship. 558 of 2023, paragraph 9, Your Lordship. Lordship, there is no fixed format of notice invoking arbitration. The requirement of law is that the party invoking arbitration must highlight the dispute between the parties and make a request that in case the disputes are not resolved, arbitration proceedings shall be commenced. The intention to invoke the redressal of disputes through arbitral process must clearly be spelled out in the notice.
Yes.
Your Lordship, the second judgment, Your Lordship, at the second judgment, Your Lordship, has also relied upon the previous one at page paragraph 26, Your Lordship.
The word no is missing from this order.
So, Your Lordship.
The word no is missing, right? I have already held in so and so that there is fixed format to issue notice invoking arbitration.
This was maybe a clerical error, Your Lordship.
I'm saying the word no is missing. Because if you read para 9,
Yes, Your Lordship.
word no is there. Yes.
Lordship, since 30 days has anyways expired, giving another notice and again coming before the court for the same dispute, Your Lordship. No submission.
Yes.
Wait, please, Lordship. My first submission is that there is no section 21 notice referring the dispute to arbitration. Your Lordship has seen my learned friend is placed on the lines of the Delhi High Court judgment. Kindly first see what is the agreement, the resolution of the dispute provided for, and what is the dispute being referred to arbitration. Kindly comes to page 82. 81 is the section 21 notice, which they say. I say it is not a section 21 notice. So I am not troubling paragraph 1, 2, 3, 4, 5, 6. Kindly comes to para 6, 82.
Yes.
His solicitor calls upon me and says that in terms of the agreement, you appoint a sole arbitrator. I say unilateral appointed, that's separate thing. But there is no dispute which he is trying to contemplate to be referred to an arbitration. There is nothing. That's one.
Sorry.
I understand. Kindly comes to page 24 once. 21.
Yes.
This is provide for resolution of the dispute. Your Lordship has seen the Delhi High Court that provides a mechanism. This has to be dispute mechanism. Now kindly see what is the dispute which can be referred to arbitration. My respect for submission of the agreement. A, in the event of any existing or
all this argue before the arbitrator. Arbitrability, anything.
I bow down. I only want to indicate one thing.
Do you dispute the lease deed?
I am not disputing anything.
You're disputing the arbitration clause.
I am disputing what my learned friend is contemplating under 21 to be referred, can't be done. Kindly here's 1 second, Your Lordship.
Yes.
In the event of an existing future dispute regarding the ownership of the building or the demise premises with
Forget that. Come to B.
Your Lordship, B has to be read with A. In the event of any controversy dispute arising out of in connection with term of this deed, both parties shall endeavor to settle the dispute negotiation within 15 days. Not done. I have not received anything because the Delhi High Court provides.
Doesn't matter. He has come here today.
He has come here, but he has to give me, Your Lordship, what he is invoking. He is invoking that I should appoint an arbitrator and come to the court. That's the obligation he is saying.
Forget it. That's the argument, then forget it.
Your Lordship, I only said is that the notice is not proper. It is not commencement of the dispute.
Take down. The petitioner has preferred the present application under Section 11(6) of the Arbitration Conciliation Act, seeking appointment of a sole arbitrator to adjudicate the disputes and differences arising out of a lease deed dated 12/8/2020 executed between the parties. Learned counsel for the petitioner submits that the parties had entered into the lease deed whereby the respondent was granted rights for installation, operation and maintenance of telecommunication infrastructure and allied equipment on the petitioner's property situated within the district of Darjeeling. Full stop. It is submitted that the lease deed was executed for a fixed tenure and contained an arbitration clause providing for resolution of disputes and differences arising out of or in connection with the said lease deed through arbitration. Learned counsel for the petitioner submits that the disputes and differences subsequently arose between the parties in relation to performance of the obligations under the lease agreement. Full stop. Accordingly, the petitioner claims have arisen on account of alleged non-payment of rent and compensation, as well as certain acts allegedly undertaken by the respondents in relation to the lease premises in contravention to the lease deed. Full stop. It is submitted that the petitioner raised grievance before the respondent and thereafter had instituted proceedings before the competent civil court by filing OC suit number 99 of 2022. You had filed it?
I had filed
Yes, yes. Full stop. Learned counsel, the petitioner states that the respondent had filed an application under Section 8 of the Arbitration and Conciliation Act, and the Learned Civil Court, by order dated 1/8/2024, referred the parties to arbitration in terms of the arbitration agreement contained in the lease deed. Full stop. Learned counsel for the petitioner further submits that notwithstanding the aforesaid order and subsequent communications issued on behalf of the petitioner seeking constitution of the arbitral tribunal, no effective steps have been taken by the respondent for appointment of an arbitrator in terms of the arbitration agreement. Full stop. He further states that notice under Section 21 had been issued on
July
17
July 25.
2025, which was duly received by the respondent, but the respondent failed to take any steps in furtherance of the said notice. Full stop. Learned counsel for the respondent objects to the present application on the ground that the notice under Section 21 has not been validly issued. Full stop. Learned counsel for the respondent states that the notice dated 17/7/2025 does not validate the claims of the petitioner. Full stop. This is it?
Yes.
Full stop. This court has considered the submissions advanced by the counsel for the parties and has perused the materials placed on record. The existence of the valid arbitration agreement between the parties is not disputed by the petition by the counsel for the parties. Full stop. The arbitration clause as contained in the said agreement is also not disputed by the counsel for the parties. Full stop. The disputes sought to be referred arise out of and in connection with the said agreement and are prima facie covered by the arbitration clause as contained in the said agreement. It is further evident that the invocation of the arbitration agreement has been carried out after the passing of the order by the civil court referring the parties to arbitration as the alleged mechanism to resolve dispute between the parties. Full stop. This court is prima facie satisfied that appropriate notice has been issued under Section 21 invoking the arbitration proceedings after the matter has been relegated by the order of the civil court dated 1/8/2024 in OC number so and so. Full stop. In such circumstances, this court is satisfied that requirements for exercise of jurisdiction under Section 11(6) of the Arbitration and Conciliation Act stands fulfilled in view of the aforesaid. This court finds sufficient ground to allow the present petition. Accordingly, how much is the dispute?
Dispute is of around 11 lakhs, Your Lordship.
Some junior member of the bar, tell me. Any name? Who's here?
Shaunak Mukhopadhyay. It's a bar library member.
I have no objection to that.
Mr. Shaunak Mukhopadhyay. Just give his
Yes, I'll just.
is appointed as the sole arbitrator to adjudicate the dispute between the parties which have arisen between the parties. Full stop. The learned arbitrator shall enter appearance in terms of upon furnishing disclosure in terms of section 12(5) of the Arbitration and Conciliation Act. All contentions of the parties on merit are kept open to be decided by the learned arbitral tribunal in accordance with law. Full stop. The remuneration of the learned sole arbitrator shall be governed by the fourth schedule of the said act or as agreed between the parties. Full stop. With the opposite direction, the present petition stands disposed. Much better.
I Victor for the
Now 40.
kindly comes to page. This is an application under section 11 for appointment of an arbitrator.
On the other side,
It was my lord kindly peruses the affidavit of service which was handed over on the last occasion. It was delivered.
Yes.
Kindly comes to page 19. That is the contents of the agreement. My lord, it's a
Who has
part-
served upon the
the respondent. My lord will see the cost title. Respondent JSB Engineering. Cost title page 2. Address at Kolkata 7070002. And that is the address which is appearing at the agreement as well. My lord will find that at page 19. JSB Engineering, my lord. And at the bottom portion, JSB Engineering having a registered office at 1/4C Khavendranath Chatterjee Road. That is the address, my lord.
Yes, sir.
It was served. Now, my lord, page 19, the agreement, my lord, the agreement contains of the clause of the agreement that they will purchase raw materials from us, my lord, of production of plastic goods. We have delivered those raw materials, my lord, which on credit, my lord, that amount is lying due, which is at due and payable. At my lord will find, and I've given a calculated statement at page 6 of my application at page 36 lakhs odd.
Arbitration clause.
Yes, my lord, I'm referring to the arbitration clause, which is at page 48. My lord will find at clause 39. There's a termination notice. My lord will find at page 151. Claiming the principal payment as well as interest thereon, my lord will find at 151. And the demand notice, my lord will find at page 153. And there's a section 21 notice as 164 to the same address.
Twenty-one is page.
21 is page 164. The relevant part of the section 21 notice is at page 168, paragraph 17. Now, on the last occasion, my lord had pointed out with regard to the track reports, my lord, of the section 21 notice, which is at page 170.
Sorry.
On the last occasion, my lord, I should be fair, my lord. On the last occasion, my lord had pointed out in 170, that is the track report of the service of my section 21 notice.
Yes.
My lord kindly sees, sent to the destination pin code is identical. It was door locked on 2nd of April, intimation delivered on 4th of April, 10th of April, it became unclaimed because it was kept in the post office for 7 days. Thereafter, it was returned to the sender. Now, my lord, this is the same notice. If my lord
But
kindly
you should have issued another section 21 to him.
No, my lord, why I say this? My lord, I brought compilation of judgments, my lord, I'll rely on. My lord, why I say this? My lord, kindly comes to the address, my lord, I pointed out in the agreement, that is one.
Section 18A.
Yes, it's for 1/46 Hogadana Chatterjee Road.
That's all right.
Yes, my lord, why I say this? My lord, kindly sees the demand notice and the demand notice at 151, and it was sent. The postal track reports are at page 159.
Yeah, I'm not denying that there is any problem with the
No, it has been delivered to that same address.
Where does it show it has been delivered from the track report?
Well, section 21, with regard to section 21, with regard to the demand notice and the one evidence of
I'm
service,
not
it is.
disputing that. I'm just saying your 21 has not been served.
Yes, my lord, it's not required to be. That is why I'm saying the
Service is
intimation.
not
No, intimation served, door locked, intimation served, unclaimed is a good service. That is what I'm trying to rely on.
Sure.
The comparison.
But the way you were reading your unclaimed is.
No, my lord, this is that's a compilation of judgment. From 1966 to 2026, there's 12 judgments are there. My lord, my lord, kindly comes to page 85. No, my lord, page 56, 2011 SCC online.
Page 50?
Page 56. This is with regard to an arbitration proceeding under section 34. Page 56, my lord. May I just read, my lord, the relevant part, my lord? Yes, my lord kindly comes to paragraph 8, which is the submission, and my lord, paragraph 11, which is the relevant portion, my lord. And I have gone, may I read, my lord?
I've gone through the pleading.
Yes, my lord. I have gone through the pleadings of the respective parties as well as the materials on record, and have considered the submissions made by the learned counsel for the respective parties. It is on record that the petitioner is running his transport business from 193 Maharishi Devendra Road, PS Jorabagan, Kolkata 6. The learned arbitrator sent the award in an envelope by registered post with acknowledgement due card on 8th of August 2008, which returned with postal endorsement not
This I'm
claimed.
not disputing. Not claimed by him is good service. Any refusal is good service. But this is not the case in your.
Yes, my lord, it is unclaimed.
Not claimed is by the sender, it has come to you. Who's
No,
the
no, no, no,
sender?
no, 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 no.
Show me from there. It is
It is intimation served. This is the postal control. My lord will find intimation served. It's there. This is the postal control.
Road locked, intimation.
Intimation served. Yes, that remark is there on the left hand portion. Yes, intimation served. This is what is returned, unclaimed by them before the postal authorities.
That's what they're saying. It's door locked.
Yes, door locked, DL and IS, intimation served.
Door lock will not amount to.
No, intimation served on the next occasion, not on the same date. My lord will find from the track report. On the 2nd of April, it was door locked. On the 4th of April, they went again. Intimation delivered. My lord, kindly see peruses the track report for once, which is at page 170. My lord, kindly sees. On 2nd of April, door locked. My lord, first remark. 4th of April, they went again.
Yes.
Intimation delivered. It's a separate day. They attempted to serve again. That is why intimation delivered. It was kept in the post office till 10th. When it was remarked was there, updated as unclaimed. Since they have not claimed it, in spite of having
It has come to you.
it has come to me on 11th. My lord, kindly see the page 171.
In claim it has come. Item returned to send. Who's the sender here?
I am the sender.
Item returned unclaimed to whom?
To me.
Yes, that's what I'm saying.
Yes. On the next day.
It's not unclaimed by the respondent.
It is. The remarks, that is what I'm submitting, my lord. It is unclaimed. The postal article is kept in the post office for a certain period of time after intimation has been given to the respondent. Now, they are to claim before the postal authorities. If it's not claimed, it is returned to the sender. That is the usual practice by the postal authorities, my lord. And that is the judgments which I say, my lord, these are the judgments, my lord. My lord? May I read the judgment? Yes. The endorsement not claimed, the envelope is sufficiently stamped, the petitioner receiving letters and correspondence that said address. It was not the case of the petitioner that the office was closed or for any other reason the envelope was not received by their office. Subsequent letters and correspondence were all received from the same address. Accordingly, there should not be any doubt to presume that the envelope which was sent at the office of the petitioner was in fact tendered by the postman at the same address, but the same has not been accepted. Now, there's a judgment reliance, my lord. After that, my lord, wherein the Honorable Division Bench have held that the notice was sent on behalf of the plaintiffs to the original defendant under registered post with AD, and the same was returned. Returned. That's the word, my lord. Returned, my lord, returned to sender. Returned with the postal endorsement not claimed, which tantamounts to good service. This returned is returned to the sender. Now, the notice itself may have validly terminated the tenancy with regard to the section such and such, my lord, which appears to be valid. Now, my lord, this is with regard to there's another judgment of this court, my lord, which I intend to rely upon. My lord will find that at 2009, 47. Yes, sir. My lord, at the end, paragraph 15, in the aforesaid circumstances or held, my lord, it was held, my lord, in my opinion, the word not claimed, paragraph 15, page 62.
Page
62 of the compilation. Paragraph 15.
Yes.
In the aforesaid circumstances, in my opinion, the word not claimed tantamount to good service, and accordingly the award was served upon the petitioner on 8th of August. Therefore, the petition is barred by limitation under subsection 3 of section 34 of the Arbitration and Conciliation Act. The return, my lord, is referring to the word return. The return was upon the sender since it was unclaimed by the respondent himself, my lord, which had to come back to me because I have sent it.
Yes.
That tantamounts to good service. My lord, there are other judgments. May I point out each and every one of them?
Show me the latest one.
The latest one is page 20, 2026.
Yes. What are
Kerala, my lord, page 87.
Yes.
Paragraph 10. This is probably with regard to, my lord, presumption of service. Now, my lord, this is also with regard to unclaimed, my lord. Paragraph 10, page 89, my lord, got no?
Yes.
The learned magistrate, while evaluating the evidence of PW1, observed that in criminal case, the burden of proof lies on the complainant and not on not only on proof of the same. The presumption under section 139 of the Negotiable Instruments Act would get attracted. My lord, kindly comes to the fifth paragraph, fifth line from the bottom. Yes, my lord, coming to the finding of the learned magistrate, it's a eighth line. Coming to the finding of the learned magistrate regarding absence of legal notice in this case, the same appears to be patently illegal. In the instance case, when exhibit P5 notice was issued, the same was returned with endorsement unclaimed. Return. Yes, my lord, the endorsement would indicate that the reason for return of the same or the refusal on the part of the address accused or addressee to accept the same. It is pertinent to note that
this case,
no, my lord, unclaimed tantamounts to refusal. That is what, my lord, it has been the judgment's pointing out. When the summons was issued to the accused in the address shown in the notice, he had accepted the same and appeared before this court in a sequel thereof. It had to have come back with the endorsement unclaimed upon service. Yeah. Acha. This is running. 20.
Yes.
Paragraph, my lord, kindly comes to page 45. That starts, the judgment starts at, my lord, page 39. That is 2008 SCC online Calcutta 343. And the relevant paragraph is paragraph 22 at page 45. The notice was sent on behalf of the plaintiffs to the original defendant under a registered post with AD, and the same was returned with the postal endorsement not claim, which tantamounts to good service. The notice itself has validly terminated its tenancy to the with regard to that notice. But the observations are it was returned with the endorsement not claimed. My lord, my lord, if my lord kindly comes to page 170 of my application, it says item kept on hold for 7 days. My lord kindly comes. Yes. Page 170, my lord, got it, my lord? Yes. Yes, my lord. The post office, my lord, will see Gugudanga IDC. That is their sub post office. But it was taken out for delivery, item kept on hold, door locked. First remark. Again taken out on delivery on 4th, Gugudanga, item kept on hold, but intimation delivered. Subsequently, when it was not claimed, my lord, there is a gap of 6 days. Since it was intimation was served, they have not claimed it from the postal department. That is why its event was updated to return to sender. This returned is in consonance with these judgments, my lord. In my humble submission, my lord, this returned to the sender with the endorsement not claimed, which tantamounts to good service. My lord, they have received the service with regard to the section 11 as well as the earlier demand notice as well as termination notice at the same address. Yes. So that is a summons substance. My lord, even my lord kindly sees the Arbitration Act. Section 21 says, may I just read section 21 for once, my lord? Yeah. Section 21 says, commencement of arbitral proceedings unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which the request for the dispute is referred to the arbitration is received by the respondent. This word is again appearing in section 34 subsection 3, which says an application for setting aside may not be made after 3 months have elapsed from the date on which the party making that application had received the arbitral award, or if a request has been made under section 33 from the date on which the request has been disposed of by the arbitral tribunal. This word received, and this has been somewhat defined in section 3, which deals with receipt of written communications, which says unless otherwise agreed by the parties, any written communication is deemed to have been received if it is delivered to the address personnel or at his person, habitual at his place or business, habitual residence or mailing address. Considering this, there's a recent judgment of the coordinate bench of this court, my lord, which I relied on an earlier occasion, my lord. That is also in the compilation, my lord, will find at page 85. Page 85, paragraph 2. It appears that the petitioner raised a dispute by invoking arbitration clause, and the notice invoking arbitration was issued on 28th of August 2025 by the learned advocate for the petitioner. It appears to this court that the said notice was posted upon due stamping at the concerned post office on 30th of August 2025. The postal department had attempted to serve the postal article upon the respondent at their last known address provided in the agreement. Under such circumstances, this court prima facie finds compliance of section 31B of the Arbitration and Conciliation Act 1996 and holds that the application before this court is maintainable as there is presumption of service of the notice under section 21 of the Arbitration and Conciliation Act. Even in this proceeding, the respondents did not appear. Similar, identical facts and circumstances.
This is an application filed under section 11(5) of the Arbitration Conciliation Act 1996, seeking appointment of a sole arbitrator to adjudicate the dispute alleged to have arisen between the parties of a purchase agreement dated 16th November 2020. Learned counsel appearing for the petitioner submits that the dispute have arisen between the parties in relation to the outstanding dues allegedly payable by the respondent. It is submitted that despite repeated demands, the respondent failed to liquidate the outstanding amount. Full stop. Accordingly, the petitioner issued a notice dated 1st April 2026 purporting to invoke the arbitration agreement contained in clause 39.2, right?
Yes, my lord.
39.2 of the purchase agreement,
39.1.
39.1 of the purchase agreement, and called upon the respondent to concur in the appointment of the sole arbitrator. The full stop. Since the respondent failed to act in terms of the said notice, the petitioner has preferred the present petition. The affidavit of service taken on record, specified service, none appears for the respondent. The court has considered the submission advanced by the counsel for the petitioner and has reduced the material placed on record. Full stop. The jurisdiction of this court under section 11 can be invoked only upon a valid invocation of the arbitration agreement in accordance with section 21 of the Arbitration and Conciliation Act 1996. The issuance of service of notice invoking arbitration cannot be an empty formality, but constitutes the very foundation of the exercise of jurisdiction under section 11. Such notice must clearly communicate to the opposite party that the disputes have arisen, that the disputes are being referred to arbitration, and afford the party an opportunity to participate in the constitution of the arbitration in terms of the agreed procedure. The petitioner has been prima facie able to establish that a valid notice has been issued under section 21 of the said act. Full stop. The petitioner has drawn the attention of this court to the fact that the respondent were intimated of the service, and in furtherance of that, the petitioner has shown that all further communications by the petitioner in terms of demand notice and other notices have been issued on the same address on which the petitioner has attempted to serve upon the section 21 notice. Since all other notices have been duly delivered on the respondent's address, the presumption that the section 21 notice has been refused despite an intimation being served upon the respondent, making the item unclaimed and returned to the sender. Full stop. Since there is no dispute that the parties have entered into the agreement dated 11th, what is it? 11th November
The agreement is dated 16th of November 2020.
which contains 16/11/2020, which contains the valid arbitration clause. This court is prima facie satisfied that the present that in the present case, an arbitrator shall be appointed in terms of the agreement between the parties. In view of the same, who should be appointed?
Mr. Banerjee is there.
Who's that? Mr. So-and-so? Mr. So-and-so is appointed as an arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter reference in due compliance with section 12(5) of the said act, he shall be entitled to fix his remuneration in terms of the fourth schedule of the said act, or with the consent of the parties. A copy of this order shall be communicated to the learned arbitrator to take necessary steps with the opposite direction the present petition stands.
I'm extremely grateful. Now, should I keep the compilation with your lordship? Because there's a pending matter which is returnable next month on the similar issue, that let it remain with. I'm grateful, my lord. Oh, no, no, yeah, no, I'm grateful, my lord.
Hey. 15 Lordship, I would like to withdraw the matter because the jurisdiction is in Delhi Lordship, with liberty to file afresh before the appropriate.
Learned counsel for the petitioner seeks to withdraw the present petition
I know, that's all.
with liberty to file appropriate proceedings in accordance with law.
Great.
The liberty as prayed for is granted. The present petition stands dismissed as withdrawn.
Great.
Now 16.
Lordship, this is my application. Service is complete for respondent number 2. For respondent number 1, the track report is inconclusive. It neither says it has been delivered or.
Then you have to serve him again. Learned counsel for the petitioner seeks and is granted liberty to effect service on respondent number 1 within a period of 2 weeks. The affidavit of service indicates that the respondent number 2 has been duly served, though none appears on behalf of the respondent number 2. List after 3 weeks. What's the name?
Ritendra Banerjee.
70.
Ritendra Banerjee.
For the petitioner, my lord, this is the affidavit of service, my lord, in 17.
Lordship, I beg to oppose this application, my lord. May I file a short affidavit, my lord? Dispute is not covered under the arbitration, my lord. I'll submit.
Problem.
My lord. Your lordship, it's an admitted position that I am one of the partners.
Let him.
Okay. Let me learn it.
My lord, 2 development agreements were there, my lord. With regard to the first development agreement, my lord, which arbitration clause is in page 40, my lord. Page 40. Page 14. With regard to the first development agreement, the petitioners, 2 petitioners and the respondent number 1 entered into one development agreement with regard to the property in dispute of respondent number 2 initially. Thereafter, my lord, subsequently second development agreement was executed between the other co-sharers, which arose from a partition suit, which was
So wait a minute. The first agreement is
between the respondent number 1, 2 and the petitioners.
1, 2 and the
Petitioners.
All right. This is the first one.
First one, my lord.
Dated.
My lord, 23rd of August, 2021.
Then,
my lord, subsequently second development agreement was executed between the petitioners, respondent number 1, and rest of the respondents except respondent number 3. They are other co-sharers. And it is dated, my lord.
Except respondent number 3.
Except respondent number 3, my lord.
Dated.
It is dated 11th of July, 2022. It starts from page 73, my lord. And in this agreement, my lord, kindly consider page 91, wherein in consonance of the first agreement, this second agreement was executed. It is mentioned. para 5, page 91, my lord. With regard to the same property in dispute in terms of the schedules, my lord, because the petitioners and the respondent number 1, 3 are partners, my lord, the dispute is respondent number 1 in nexus with the other respondents behind back of the petitioners have transferred several units after construction of the multi-storied building, have transferred several units of the said multi-storied building to the third parties, which is the crux of the main dispute, my lord. My lord, thereafter kindly consider 21, section 21 notice was issued. It is in page 139, starts from 139.
Okay, second one.
And context of the notice was starts from page 141.
So those people who are not part of the agreement, how can you?
No, these people are part of the agreement. But the other co-sharers, my lord, they are the parties in the second development agreement, my lord. And both the development agreements are consisting arbitration clause, my lord.
That's right. But then there are two separate agreements.
With regard to the same,
same set of parties are not there. Maybe it's the same property.
My lord.
But the same set of parties are not there.
Notice was issued against all the parties. Even section 9 was.
But notice can only be issued against people who are part of the contract, right? It can't. You can issue notice against anyone.
No, they are the.
But you can always allege,
my lord,
or seek an arbitration against a person who's a signatory to the arbitration. So maybe in the first round of your agreement, X, Y, Z were there. But in the second round of your agreement, though the agreement might be carried forward to the second round, but they are not parties or some other parties have been added.
My lord.
Then
yes. My lord, in section 9 application with humble submission, in section 9 application, they have not raised any objection with regard. Even they have not appeared, my lord. The interim order is still in existence.
That's all right. They'll file their application in section 9. They have not chosen to do anything, but yeah, what is your
My lord, I appear for the respondent number 1. I am one of the partners of the partnership firm. It is the admitted position that the partnership firm had entered into a development agreement with the landowners. Now, the partnership firm, there is a dispute between the partnership firm, between me and my other partner. Now, what he is trying to seek a remedy by relying on this development agreement, he is seeking his grievance against the partner, and the partnership firm has not been made a party to this proceeding. And more so, my lords,
the agreement is between the partnership firm or the individual partners?
my lord, the arbitration, there is a partnership deed. In there, my lord, there is no partnership. That partnership deed is unregistered. He has not placed reliance on that partnership deed. He is relying on the arbitration clause in the development agreement, whereas his dispute is entirely on the partnership deed. Kindly takes his section 21 notice at page 142. Can I read it for your lordship? Second paragraph. In the meantime, my clients came to know that you formed a nexus with one of our partners, that is my client, that is addressee number 1, and sold out flats to different persons by registered deed of sale. There are 23 flats have been sold together with entire ground floor comprising garages and shops, and also sold to different persons, depriving my clients from getting their legitimate share. Practically, you owners of the said property under development addressee 2 to 13 in connivance with one of the partners of my clients, that is addressee number 1, practically siphon my client's share. Share of profits. My lord knows partnership agreement, my lord, is a share of profits. So his entire grievance is against me. And the partnership deed, my lord, is unregistered. and this partnership firm has not been made party to this instant proceeding. It's a dispute purely between the partners.
And the agreement is between the partnership firm.
Partnership
Yes,
firm and the
kindly take-
partners, my lord.
Why you have not made the partnership firm?
Yes, my lord, kindly take.
My lord, partners are made party, my lord.
But
Partners,
the
my lord.
partnership firm, my lord.
My lord. My lord, may I come back tomorrow? I'm late by Mr. Sanjay Mukherjee. My lord, may I come back tomorrow?
Not. May I seek a direction for filing affidavits, my lord?
Let Mr.
Now 18.
It's my section 11 application, your
on the
lordship.
other side.
The respondents have been served, your lordship. The item has been delivered on. I hand up the affidavit of service.
Not today.
Your lordship,
Wednesday. Have it on Wednesday.
very good.
Not today, not today.
Affidavit of service are recorded.